I never imagined that inheriting my grandfather's rustic cabin in the mountains of North Carolina would turn into a legal nightmare that would consume 2 years of my life. But here I was, sitting across from a federal judge while the HOA president's face turned progressively redder with each piece of evidence my attorney presented. My name is Brandon Elliott, and I'm a software developer from Charlotte. I'd always been close to my grandfather, spending summers at his cabin near Asheville when I was growing up. The place was tucked away in a small development called Mountain Vista Estates, surrounded by towering pines and offering a view of the Blue Ridge Mountains that could take your breath away. When Grandpa died 3 years ago, he left the cabin to me in his will. It was a simple 2-bedroom structure built in the 1970s, nothing fancy, but it sat on 2 acres of prime mountain property and had been in our family for decades. I visited the cabin occasionally on weekends, using it as a retreat from the chaos of city life. The HOA had always been relatively quiet during Grandpa's time there. He paid his dues, kept the property maintained, and nobody bothered him. I figured things would continue the same way under my ownership. I was wrong. It started on a Saturday morning in April when I drove up to the cabin for a long weekend. I'd been working 70-hour weeks on a major project and desperately needed the break. As I pulled into the gravel driveway, I noticed an official-looking notice taped to my front door. My stomach sank. Nothing good ever came from official notices taped to doors. I parked and walked up to read it. The notice was from the Mountain Vista Estates HOA, signed by someone named Karen Reynolds, who identified herself as the HOA president. The letter informed me that my property was in violation of several covenants and demanded immediate compliance. I read through the list with growing disbelief. According to Karen, my cabin's exterior paint was unacceptable and in poor condition. My landscaping was inadequate and not in keeping with community standards, and my mailbox was damaged and presenting an eyesore. I looked around my property. The cabin had natural wood siding that Grandpa had treated and sealed just 4 years ago. It was supposed to look rustic. That was the whole point. The landscaping was native plants and natural mountain vegetation, which required minimal maintenance and was actually better for the local ecosystem. And my mailbox was perfectly fine, a sturdy black metal box that matched every other mailbox on the street. I crumpled the notice and tossed it on the kitchen counter, deciding to deal with it after my weekend. I wasn't going to let some busybody HOA president ruin my vacation. That evening, as I sat on the back deck watching the sunset paint the mountains in shades of orange and purple, I heard a car pull up. Moments later, there was an aggressive knock at my door. When I opened it, I found myself facing a woman in her mid-50s with blonde hair cut in that distinctive style that somehow all difficult middle-aged women seem to favor. She wore expensive athletic wear and an expression of barely contained irritation. "You must be Brandon Elliott," she said, not waiting for confirmation. "I'm Karen Reynolds, president of the Mountain Vista Estates HOA. I see you received our notice." "I did," I replied, keeping my tone neutral. "I'm not sure I understand the violations you mentioned. My property looks fine to me." Karen's lips thinned. "Mr. Elliott, your grandfather was given considerable leeway during his final years due to his age and health. However, now that the property has changed hands, we expect full compliance with our covenants. The standards in this community are very high, and frankly, your cabin is dragging down property values." I felt my jaw tighten. My grandfather maintained this property beautifully. Nothing has changed since he owned it. "That's precisely the problem," Karen said. "The cabin is outdated. The natural wood siding is not permitted under our current architectural guidelines. All homes must have painted exteriors in approved colors. Your landscaping lacks the manicured appearance we require, and your mailbox has a visible dent." I hadn't noticed any dent on my mailbox, but I wasn't about to get into an argument about it on my doorstep. When did these rules change? My grandfather never mentioned any of this. "The covenants were updated 2 years ago at our annual meeting," Karen said primly. "All homeowners were notified by mail." "I wasn't at that meeting. I don't even live here full-time." "That's not our problem, Mr. Elliott. You're responsible for knowing and following the rules. You have 30 days to bring your property into compliance, or we'll begin assessing daily fines of $100. I stared at her. $100 per day? For what exactly? My property looks like every other cabin in this neighborhood. I don't appreciate your tone, Karen snapped. The HOA board has discussed your property extensively, and we're in unanimous agreement that significant improvements are required. If you're unable or unwilling to make these improvements, perhaps you should consider selling. There it was. Something about the way she said it made alarm bells go off in my head. I'm not interested in selling. This cabin has been in my family for decades. Karen's expression was calculating. Well, that's your choice, of course. But I should mention that my son, Derek Reynolds, is actually in the market for a property in this area. He's recently gotten engaged and is looking for a mountain retreat. I'm sure he'd be willing to make you a fair offer, and it would save you the expense and hassle of all these required improvements. Now it made sense. This wasn't about covenants or community standards. Karen wanted my property for her son, and she was using her position as HOA president to pressure me into selling. I'm not interested, I said firmly. Now, if you'll excuse me, I came here to relax. I closed the door before she could respond. Through the window, I watched her stand on my porch for a long moment, her face flushed with anger, before she finally stalked back to her car and drove away. I spent the rest of the weekend trying to enjoy myself, but Karen's visit had poisoned the atmosphere. I kept thinking about those ridiculous violations and the threat of $100 daily fines. When I got back to Charlotte on Sunday evening, I dug out my grandfather's papers and found his copy of the original HOA covenants from when the development was first created in 1972. I read through them carefully. The original covenants were simple and reasonable. They required homes to be maintained in good repair, prohibited commercial activities, and set basic standards for things like noise and nuisance. There was nothing about specific paint colors or landscaping styles. There was a provision allowing the covenants to be amended, but it required a 2/3 vote of all homeowners. I wondered if Karen's updated covenants had actually been properly approved. It seemed like something I should investigate. The following weekend, I drove back to the cabin with a plan. I'd noticed a few other properties in the development that looked similar to mine, with natural wood siding and native landscaping. I wanted to see if Karen was targeting them with the same violations or if I was being singled out. I knocked on the door of the cabin 3 properties down from mine, which had similar wood siding. An older man named Tom Hartley answered. He'd lived in Mountain Vista Estates for 15 years and was happy to talk about the HOA. Karen's a piece of work, Tom said, shaking his head. She got herself elected president about 3 years ago, and it's been downhill ever since. She's constantly trying to impose new rules and regulations. Most of us just ignore her. Has she cited you for any violations? I asked. Oh, sure, I get notices all the time. She doesn't like my wood siding either, but I just file them in the trash. The HOA has no real enforcement power. The original covenants are pretty loose, and as long as you're not doing anything extreme, there's not much she can actually do about it. That was encouraging. What about those updated covenants she mentioned, the ones that supposedly require painted exteriors and specific landscaping? Tom snorted. She tried to pass those about 2 years ago, sent out this whole packet of new rules and claimed they'd been approved at the annual meeting. But here's the thing. That meeting didn't have enough people present to constitute a quorum. Only about 15 homeowners showed up out of 63 properties in the development. They didn't have the votes to change anything. A bunch of us sent letters objecting, and the whole thing just kind of fizzled out. Karen still acts like her new rules are valid, but they're not legally binding. This was exactly what I needed to know. So if she tries to fine me, I can just refuse to pay? Technically, yes, but Karen's pretty vindictive. She'll make your life miserable if she decides she doesn't like you. My advice? Keep good records of everything, document all your interactions with her, and don't let her bully you. I thanked Tom for his time and headed back to my cabin feeling more confident. Karen was running a bluff, using her position to intimidate people into compliance with rules that didn't actually exist. As long as I stood my ground, she couldn't do anything to me. I was about to learn just how wrong that assumption was. 2 weeks later, I received a certified letter from the HOA. It was a formal notice of violation, listing the same complaints as before, and informing me that I'd failed to comply within the 30-day window. As a result, the HOA was now assessing fines of $100 per day, starting immediately. The letter stated that if I didn't pay the accumulated fines and correct the violations within 60 days, the HOA would place a lien on my property. I immediately called Tom Hartley. Can they actually do this? Can they put a lien on my property for violating rules that aren't even valid? Tom sighed. They can try. Whether it would hold up in court is another question. You might want to talk to a lawyer. I didn't want to spend money on a lawyer for what seemed like a frivolous dispute. So instead, I decided to attend the next HOA board meeting and address the issue directly. The meetings were held on the first Tuesday of each month at the community center in the development. I arrived 15 minutes early to find only a handful of people there. Karen sat at a table at the front of the room with two other board members, a thin man in his 60s named Paul Mitchell and a woman in her 40s named Linda Chen. As homeowners trickled in, I counted maybe 12 people total, including the board members. Karen called the meeting to order and launched into a long, boring discussion of the HOA's finances. I waited impatiently through reports on the community mailbox maintenance and the landscaping contract for the common areas. Finally, she opened the floor for homeowner comments. I stood up. I'm Brandon Elliott. I own the property at 247 Ridgeline Drive. I received a notice of violation and a letter about fines, and I'd like to discuss it. Karen's expression hardened. Mr. Elliott, yes, your property has been the subject of considerable discussion by the board. Do you have questions about the violations? I have questions about the validity of the covenants you're claiming I violated. I've reviewed the original covenants from 1972, and they don't include any of the requirements you mentioned. I spoke with other homeowners who say the amended covenants were never properly approved. A murmur went through the small crowd. Paul Mitchell shifted uncomfortably in his chair. Karen's voice turned icy. The amended covenants were approved at our annual meeting 2 years ago, following all proper procedures. The vote was recorded in our minutes. How many homeowners were present at that meeting? I asked. That's not relevant, Karen snapped. It's absolutely relevant. The original covenants require a 2/3 vote of all homeowners to approve amendments. That means you'd need votes from at least 42 of the 63 properties. Were 42 homeowners present? Karen's face flushed. The vote was conducted among the homeowners in attendance, as is standard procedure. That's not what the covenants say, I pressed. If you didn't have the required votes, then your amended covenants aren't valid, and neither are the violations you're claiming or the fines you're trying to assess. Mr. Elliott, Karen said, her voice shaking with barely controlled anger, you're out of order. The board has made its decision regarding your property. If you refuse to comply, we will take all necessary legal action to protect the interests of this community. I'm not trying to be difficult, I said, keeping my voice calm. I just want to understand the rules I'm supposed to follow. If you can show me documentation that the amended covenants were properly approved with the required votes, I'll be happy to comply. This meeting is not the appropriate forum for your personal grievances, Karen said. If you have issues with the board's decisions, you're welcome to hire an attorney and pursue the matter through proper legal channels. Now, if there's no other business— Wait, said a woman I didn't recognize sitting near the back. I'd like to hear more about this. I received violation notices too, and I've been wondering about whether those new rules are actually valid. Me too, said another man. Karen, I think we deserve an answer. How many people voted to approve the amended covenants? Karen stood abruptly. This meeting is adjourned. Any further questions can be submitted to the board in writing. She gathered her papers and walked out, leaving Paul and Linda sitting awkwardly at the table. I approached Paul Mitchell. Can you tell me about that vote 2 years ago? He looked uncomfortable. Look, I wasn't on the board back then. Karen was elected president right after that meeting. I can't really speak to what happened. Who was on the board at that time? Karen, obviously, and 2 other people who've since moved away. I joined the board about a year ago. Is there anyone who has copies of the minutes from that meeting? Paul shrugged. Karen keeps all the official records. You'd have to ask her. I left the meeting frustrated, but more determined than ever. Karen was clearly hiding something about those amended covenants. I suspected she'd pushed them through without proper approval and had been counting on homeowners being too passive or intimidated to challenge her authority. Over the next week, I did some digging. I contacted the county clerk's office to see if the amended covenants had been officially recorded. They hadn't. I then sent a formal written request to Karen asking for copies of the meeting minutes from the annual meeting 2 years ago, including attendance records and vote counts. I sent it via certified mail so I'd have proof she received it. Her response came 10 days later. It was brief and unhelpful. She claimed the meeting minutes were available for review at the next board meeting, but couldn't be copied or distributed due to privacy concerns. She provided no attendance records or vote counts. Meanwhile, the daily fines continued to accumulate on paper. According to Karen's calculations, I now owed the HOA over $3,000. Then, things took a darker turn. I drove up to the cabin on a Friday evening in late May, looking forward to a peaceful weekend. As I turned onto Ridgeline Drive, I noticed something strange. There was a large sign planted in my front yard that read, "Property not in compliance with HOA standards." It was printed in bold red letters on a white background, clearly visible from the road. I pulled into my driveway, furious. I yanked the sign out of the ground and carried it around to the back of the cabin, where I left it leaning against the woodshed. Then I noticed something else. My mailbox, which had been perfectly fine before, now had a large dent in the side, exactly as Karen had originally claimed. Someone had deliberately damaged it. I took photos of everything with my phone, documenting the sign and the damaged mailbox. This was harassment, plain and simple. The next morning, I woke to find the sign had been returned to my front yard. I pulled it up again, and this time locked it in my shed. By Sunday afternoon, there was a new sign, this one reading, "HOA violations. Owner refuses to comply." I called the local sheriff's office and filed a report about the harassment. The deputy who took my statement was sympathetic, but explained there wasn't much he could do unless I had evidence of who was placing the signs. He suggested I install a security camera. That week, I ordered a wireless camera system online and had it shipped to my apartment in Charlotte. The following weekend, I installed cameras covering my front yard, driveway, and the approach to my cabin. They were motion activated and would send alerts to my phone. I didn't have to wait long for results. On Tuesday evening, while I was at my apartment in Charlotte, my phone buzzed with a motion alert. I pulled up the camera feed and watched in real time as a young man in his late 20s climbed out of a silver SUV and walked across my lawn carrying another sign. He planted it in the front yard, took a photo with his phone, and left. I saved the video footage. The license plate on the SUV was clearly visible. I ran it through a public record search and confirmed what I already suspected. The vehicle was registered to Derek Reynolds, Karen's son. Now I had evidence. I filed another report with the sheriff's office, this time including the video footage. The deputy said he'd follow up with Derek about the trespassing and harassment. But Karen wasn't done. The next week, I received a letter from a law firm in Asheville. It was a formal demand letter on behalf of the Mountain Vista Estates HOA, claiming I owed over $4,000 in unpaid fines and threatening legal action if I didn't pay immediately and bring my property into compliance. The letter also mentioned that the HOA was prepared to place a lien on my property to secure the debt. I realized I couldn't handle this on my own anymore. I needed a lawyer. I found an attorney in Asheville named James Morrison who specialized in HOA disputes. I met with him the following week and laid out everything that had happened: the dubious amended covenants, the harassment, the signs, Karen's obvious conflict of interest in wanting the property for her son, and now the threat of a lien. James listened carefully, taking notes. When I finished, he sat back in his chair and steepled his fingers. "This is a solid case," he said. "The HOA president is clearly abusing her authority. The amended covenants almost certainly aren't valid if they didn't get the required votes. The harassment is documented, and the fact that she's trying to pressure you into selling to her son creates a massive conflict of interest." "What should I do?" I asked. "First, we send a response to their demand letter, denying all liability and putting them on notice that we believe they're acting in bad faith. Second, we file for a declaratory judgment asking the court to rule on the validity of the amended covenants. Third, if they actually place a lien on your property, We'll fight to have it removed and potentially sue for damages. How much is this going to cost me? James quoted me a retainer fee that made me wince, but I paid it. This wasn't just about money anymore. It was about principle. Karen had been bullying people in this community for years, and someone needed to stand up to her. James drafted a detailed response to the demand letter, methodically dismantling each of the HOA's claims. He pointed out that the amended covenants had never been properly approved or recorded, that the alleged violations were not violations under the original covenants, and that the fines were therefore invalid. He also noted the documented harassment and Karen's conflict of interest regarding her son's desire to purchase the property. The letter concluded with a warning that if the HOA continued its campaign of harassment or attempted to place a lien on the property, we would pursue all available legal remedies, including claims for abuse of process and intentional infliction of emotional distress. We sent the letter via certified mail and waited. The response came not from Karen or the HOA's attorney, but from Derek Reynolds himself. He called me on my cell phone on a Wednesday evening. "Mr. Elliott, this is Derek Reynolds. I think we got off on the wrong foot here. I'd like to talk to you about your property." "I'm listening," I said cautiously. "Look, I know my mom came on a bit strong with the HOA stuff. She can be intense about community standards, but the truth is, I am genuinely interested in buying your cabin. I'm getting married in a few months, and my fiancé and I love the Mountain Vista area. Your property would be perfect for us. I'm prepared to make you a very fair offer." "What's your definition of fair?" I asked. "Well, given the issues with the property and the expenses you'd need to incur to bring it up to code, I was thinking somewhere in the range of $110,000. I almost laughed. I'd had the property appraised when I inherited it, and it was valued at $320,000. The land alone was worth at least $200,000. "That's not even close to fair," I said. "That's insulting." "Mr. Elliott, be reasonable. You're facing significant fines from the HOA, legal expenses, and the cost of all the required repairs and updates. By the time you deal with all of that, you'll be underwater on this property. I'm offering you a clean exit." "Let me be clear," I said, my voice hard. "I'm not selling my cabin to you for any price. This property has been in my family for decades, and it's going to stay that way. And if you or your mother continue to harass me, I'll make sure you both regret it." Derek's tone turned cold. "That sounds like a threat." "It's a promise. I have video evidence of you trespassing on my property multiple times. I've filed police reports, and my attorney is preparing legal action against the HOA, so back off." I hung up before he could respond. Looking back, I realized the conversation was the point of no return. Up until then, there might have been a chance for de-escalation. But after I firmly rejected Derek's offer and made it clear I wouldn't be intimidated, Karen decided to escalate to nuclear levels. The following week, the HOA filed a lawsuit against me in county court seeking payment of the accumulated fines, now totaling over $5,000, plus attorney's fees. They also filed a lien against my property with the county clerk's office. James Morrison immediately filed a motion to dissolve the lien and a counterclaim on my behalf. We argued that the HOA's actions were retaliatory, that the fines were based on invalid covenant amendments, and that Karen had a conflict of interest that tainted the entire proceeding. We also filed a separate lawsuit seeking damages for harassment and abuse of process. But Karen had one more trick up her sleeve, and it was the dirtiest play yet. 2 weeks after the lawsuits were filed, I received notice from the county that I was being cited for zoning violations. According to the notice, my cabin was being used as a short-term rental without proper permits and licensing, which violated local zoning ordinances. The penalty for illegal short-term rental activity could include substantial fines and potentially a court order to cease all use of the property. This was completely false. I'd never rented out the cabin, not even once. It was purely for my personal use. But someone had filed a complaint with the county zoning office claiming I was running an illegal Airbnb operation. I immediately suspected Karen was behind it, but I couldn't prove it. The zoning complaint had been filed anonymously. I had to spend hours gathering documentation to prove I wasn't operating a short-term rental. bank statements showing no rental income, utility bills in my name, statements from neighbors confirming they'd only ever seen me at the property, and affidavits swearing I'd never advertised or rented the cabin. I submitted everything to the zoning office and requested a hearing. At the hearing, the county zoning officer reviewed my evidence and seemed satisfied that the complaint was baseless, but he explained that they were required to investigate all complaints, and the investigation would remain open for 30 days in case any additional evidence surfaced. During that time, I was advised not to use the property out of an abundance of caution. I was being forced out of my own cabin by a false accusation. James Morrison was furious when I told him. "This is witness tampering and abuse of process," he said. "We can add it to our lawsuit, but more importantly, I think we need to consider whether this case belongs in federal court." "Federal court?" I repeated. "Why would this be a federal case?" "Because Karen's not just violating state HOA laws, she's potentially violating your constitutional rights. As president of the HOA, she's exercising governmental or quasi-governmental authority over your property. When she uses that authority to deprive you of your property rights for her own personal benefit, specifically to enrich her son, that could constitute a violation of your due process rights under the 14th Amendment. There's also a potential civil rights claim under Section 1983 for deprivation of rights under color of state law." I was skeptical. Would that actually work? I mean, she's not a government official. She's just a HOA president. HOAs occupy a weird space legally, James explained. They exercise many powers traditionally held by governments. They can impose rules, levy fines, and in some cases even foreclose on properties. Courts have recognized that when HOAs abuse these powers, particularly when there's corruption or personal enrichment involved, it can rise to the level of a constitutional violation. It's not a guaranteed win, but we have a strong argument here, especially with the documented conflict of interest and the pattern of harassment. What's the advantage of going to federal court? Several things. First, federal judges tend to take constitutional claims seriously. Second, if we win, we can recover attorney's fees under Section 1983, which would help offset your legal costs. Third, a federal civil rights lawsuit sends a strong message that this kind of behavior won't be tolerated. And fourth, it gets us out of local county court, where Karen might have relationships with the judges. "Do it," I said. "File in federal court." James filed our lawsuit in the United States District Court for the Western District of North Carolina. The complaint was detailed and damning. It named Karen Reynolds, Derek Reynolds, and the Mountain Vista Estates HOA as defendants. It alleged violations of my civil rights under the 14th Amendment and Section 1983, abuse of process, intentional infliction of emotional distress, harassment, and tortious interference with property rights. We sought compensatory damages, punitive damages, attorney's fees, and injunctive relief ordering the HOA to cease all enforcement actions against me and to remove the lien from my property. The complaint laid out the entire timeline. Karen's initial approach about violations that didn't exist under the valid covenants, her suggestion that I sell to her son, the escalating harassment when I refused, Derek's lowball offer and his trespassing to plant signs, the filing of a baseless zoning complaint, and the HOA's retaliatory lawsuit and lien. We argued that Karen had systematically abused her authority as HOA president to deprive me of my property rights for her son's personal benefit, and that this conduct shocked the conscience and violated fundamental principles of due process. The defendants had 30 days to respond. Their answer, when it came, was predictably dismissive. They denied all wrongdoing and claimed that Karen had been acting within her authority as HOA president to enforce legitimate covenants. They argued that my federal claims should be dismissed because an HOA is a private entity, not a state actor, and therefore couldn't violate my constitutional rights. James had anticipated this argument. The question of whether HOAs are state actors for constitutional purposes is complicated and depends on the specific facts. We filed a detailed brief arguing that the Mountain Vista HOA was exercising governmental functions and that Karen's abuse of authority was sufficient to constitute state action under several established legal theories. The The judge assigned to our case was the Honorable Margaret Chen, a federal district judge with a reputation for being smart, fair, and not suffering fools gladly. She scheduled a hearing on the defendant's motion to dismiss for late September. In the meantime, discovery began. Discovery is the phase of litigation where both sides exchange documents and information. James sent out extensive discovery requests to the defendants, demanding production of all HOA records, meeting minutes, correspondence, financial documents, and communications related to my property. Karen fought us every step of the way. She claimed various documents were privileged or confidential. She produced heavily redacted meeting minutes. She delayed responses and played procedural games. But we got enough to confirm what I'd suspected all along. The amended covenants had never been properly approved. The meeting minutes from 2 years ago showed that only 17 homeowners had attended the annual meeting, far short of the quorum required to amend the covenants. The vote to approve the amended covenants had been 14 in favor, 3 opposed. That was nowhere near the 42 votes needed under the original covenants. Even better, we found emails between Karen and Derek discussing my property. In one email, sent just a week before Karen first approached me about violations, Derek wrote, "Mom, I really want that cabin on Ridgeline. It's perfect for me and Sarah. Can you help me make it happen?" Karen had responded, "Don't worry, sweetheart. I'll take care of it." The emails were smoking gun evidence of Karen's conflict of interest and her intent to use her HOA position to benefit her son. We also found records showing that Karen had never cited any other property in the development for having natural wood siding or native landscaping. I was the only homeowner being targeted for these supposed violations. This supported our claim that the enforcement action was selective and retaliatory. In October, we appeared before Judge Chen for the motion to dismiss hearing. The courtroom was formal and intimidating, with high ceilings and dark wood paneling. Karen and Derek sat at the defendant's table with their attorney, a silver-haired man named Robert Davenport who specialized in HOA law. Davenport argued first, making the case that HOAs are purely private organizations and therefore can't be sued for constitutional violations. Your Honor, HOAs are voluntary organizations formed by private contract. They're not state actors. They don't receive government funding or exercise government powers. They simply enforce private agreements between neighbors. Mr. Elliott's claims should be dismissed for lack of subject matter jurisdiction. Judge Chen listened impassively, occasionally making notes. When it was James's turn, he stood and addressed the judge with confidence. Your Honor, while it's true that HOAs are nominally private organizations, they exercise many powers traditionally held by governments. They impose rules that govern how property owners can use their land. They levy taxes in the form of dues and assessments. They impose fines and penalties. They can even foreclose on properties. In this case, the Mountain Vista HOA has gone even further, filing liens and attempting to force Mr. Elliott to forfeit his property rights. But Mr. Morrison, Judge Chen interjected, don't homeowners voluntarily agree to these restrictions when they purchase property in an HOA? They do, Your Honor, but that doesn't give HOA officials carte blanche to abuse their authority. When a HOA president uses her position to enrich her family member by selectively enforcing invalid rules and harassing a homeowner into selling his property below market value, that's not legitimate covenant enforcement. That's extortion under color of authority. And when that authority is quasi-governmental in nature, it triggers constitutional protections. Judge Chen considered this. What about the specific facts here? You've alleged that Ms. Reynolds acted with corrupt motives to benefit her son. If that's true, does that convert what would otherwise be a private contract dispute into a constitutional case? Yes, Your Honor. We have substantial evidence that Ms. Reynolds specifically targeted Mr. Elliott because her son wanted his property. She fabricated violations based on covenant amendments that were never properly approved. She orchestrated a campaign of harassment. She filed a baseless zoning complaint to force him out of his property, and she did all of this using the coercive powers of the HOA. This isn't just a contract dispute. It's an abuse of authority that deprived Mr. Elliott of his property rights without due process. The hearing lasted over an hour, with both sides presenting detailed legal arguments. At the end, Judge Chen took the matter under advisement, meaning she'd issue a written ruling later. We waited 6 weeks for the decision. When it came, it was a significant victory. Judge Chen denied the defendant's motion to dismiss, finding that we had adequately alleged facts that, if proven, could constitute state action and a violation of due process rights. She wrote in her opinion that HOAs occupy a unique legal space and that their exercise of coercive powers over property rights requires careful judicial scrutiny, especially where there are allegations of corruption or personal enrichment. She also noted that the alleged facts, particularly the emails between Karen and Derek, suggested a disturbing pattern of abuse of authority for private gain. The ruling meant our case would proceed. We were going to get our day in court. The defendants tried one more gambit to avoid trial. In December, they made a settlement offer. They would withdraw all fines and violations against me, remove the lien from my property, and pay $20,000 toward my attorney's fees. In exchange, I would dismiss the lawsuit and sign a release agreeing not to pursue any further claims. James and I discussed it. "It's not a terrible offer," he said. "You'd be made whole, at least partially, and you'd avoid the uncertainty of trial." But I wasn't interested. "They're trying to buy their way out of accountability," I said. "Karen has been abusing her authority for years, bullying people in that community. If we settle, she'll just keep doing it to someone else. I want a public judgment against her. I want a jury to hear what she did and hold her accountable." "That's going to mean more legal fees," James warned, "and there's always a risk at trial. Juries are unpredictable." "I understand, but I'm not settling. Let's take this to trial." We rejected the settlement offer. The case was scheduled for trial in March. Discovery continued through the winter. We deposed Karen, Derek, and several other HOA board members. Karen's deposition was particularly revealing. She was combative and defensive, clearly uncomfortable being questioned under oath. When James asked her directly about the emails discussing Derek's interest in my property, she claimed she didn't remember them and that they were taken out of context. When pressed about why only my property had been cited for violations, she insisted it was simply because mine was the most egregious case, though she couldn't explain what made it more egregious than other similar properties. Derek's deposition was equally damaging. He admitted that he'd wanted my property and had discussed it with his mother. He also admitted to placing the signs in my yard, but claimed he'd done so on behalf of the HOA and didn't think it was a problem. When James showed him the video footage of him trespassing, he became flustered and defensive. We also deposed several other homeowners in Mountain Vista Estates who testified about Karen's pattern of aggressive enforcement and her tendency to target people she didn't like. One woman testified that Karen had cited her for violations after they had a disagreement at a board meeting. Another testified that Karen had threatened to fine him if he didn't vote for her preferred candidate for the board. As trial approached, James and I prepared extensively. We organized hundreds of pages of documents into exhibits. We prepared witness examinations. We drafted opening and closing statements. James explained that our goal was to make the jury angry about what Karen had done, to make them understand that this wasn't just a property dispute, but an abuse of power that threatened everyone's rights. The trial began on a cold Monday morning in early March. The courtroom was packed with people from Mountain Vista Estates who'd come to watch. Tom Hartley was there, along with several other neighbors I'd met during my investigation. Jury selection took most of the day. James and Davenport questioned potential jurors, looking for people who could be fair, but also people who would be sympathetic to our respective positions. By the end of the day, we had a jury of 8 people, 5 women and 3 men, ranging in age from their 30s to their 60s. The next morning, we began with opening statements. Davenport went first, arguing that this was simply a case of an HOA president trying to enforce legitimate rules and a stubborn homeowner who refused to comply. He portrayed Karen as a dedicated volunteer trying to maintain property values in her community, and me as a troublemaker looking for a payday. Then it was James's turn. He walked the jury through the entire timeline, showing how Karen had specifically targeted me after her son expressed interest in my property. He displayed the emails between Karen and Derek on a large screen. He showed the jury photos of my property and asked them if it really looked like an eyesore. He explained how the amended covenants had never been properly approved and how Karen had knowingly enforced invalid rules. He described the harassment, the signs, the false zoning complaint. By the time he finished, the jury looked disturbed. We spent the next 3 days presenting our case. I testified about my grandfather's cabin, the harassment I'd experienced, and the emotional toll it had taken. James walked me through each incident, making sure the jury understood the full scope of what had happened. When Davenport cross-examined me, he tried to paint me as oversensitive and litigious, but I stayed calm and simply told the truth. We called Tom Hartley and other homeowners who testified about Karen's pattern of abuse. We called a handwriting expert who testified that the anonymous zoning complaint had been written on a computer traced to Karen's IP address. We called a real estate appraiser who testified that my property was worth over $300,000, making Derek's offer of $110,000 grossly inadequate. Perhaps most damaging was when we called Paul Mitchell, the current HOA board member. James asked him about the meeting where the amended covenants were supposedly approved. Paul testified that he'd reviewed the records after my complaints and had concluded that the amendments were never properly approved. He also testified that Karen had resisted all efforts to clarify the issue or hold a new vote. "Did you ever discuss with Ms. Reynolds the fact that the amended covenants might not be valid?" James asked. "Yes, I did," Paul said. "What was her response?" "She said it didn't matter, that nobody was going to challenge her on it, and that we needed to maintain appearances." "Did she specifically mention Mr. Elliott's property?" Paul hesitated, then nodded. "She said Mr. Elliott's property was a special case, and that we needed to be aggressive in pursuing the violations." "Did she explain why it was a special case?" "Not directly, but I knew her son wanted to buy it. Everyone on the board knew." The jury members were leaning forward, listening intently. The defendants presented their case over the next 2 days. Karen testified that she'd acted in good faith, believing the amended covenants were valid and that my property genuinely violated community standards. She denied any corrupt motive and claimed that her discussions with Derek about the property were just casual conversations between a mother and son. The jury didn't seem to buy it. Several jury members looked skeptical during her testimony, and one woman actually shook her head when Karen claimed she didn't remember the email where she'd promised to take care of getting the property for Derek. Derek testified that he'd made a legitimate offer for my property and didn't understand why I was so offended by it. When James cross-examined him about the offer being less than a third of the property's appraised value, Derek claimed he'd based his offer on what he could afford, not on the actual market value. "So you expected Mr. Elliott to sell you a $300,000 property for $110,000? James asked. "I thought he'd be motivated to sell because of the HOA issues," Derek admitted. "The HOA issues that your mother created?" "Objection," Davenport called out. "Sustained," Judge Chen said, but the point had been made. Closing arguments took place on a Friday afternoon. Davenport argued that we hadn't proven our case, that HOAs have a legitimate right to enforce covenants, and that any problems with the amended covenants were a separate issue that didn't justify damages. He urged the jury to reject what he called our sensationalized claims. James's closing was passionate and powerful. He reminded the jury of all the evidence, the emails, the harassment, the false zoning complaint, the grossly inadequate purchase offer, the invalid covenants. He explained that this case was about more than just one cabin or one HOA president. It was about the fundamental right to own and enjoy property without being subjected to corrupt abuse of authority. "The defendants want you to believe this is just a simple contract dispute," James said. "But it's not. Karen Reynolds used her position of power to try to steal Brandon Elliott's property for her son. She fabricated violations. She imposed illegal fines. She harassed and intimidated him. She filed false complaints with the government, all in an attempt to force him to give up property that had been in his family for decades. That's not contract enforcement. That's extortion, and it violates the most basic principles of due process and property rights. I'm asking you to hold Karen Reynolds and the HOA accountable for what they did." The jury deliberated for 6 hours. When they returned, the forewoman announced that they'd reached a verdict. The verdict form had multiple questions. On the question of whether the HOA had violated my property rights through selective and retaliatory enforcement of invalid covenants, the jury answered yes. On the question of whether Karen Reynolds had acted with corrupt motives to benefit her son, the jury answered yes. On the question of whether I had suffered damages as a result, the jury answered yes. Then came the damages award. The jury awarded me $75,000 in compensatory damages for my legal fees, emotional distress, and loss of enjoyment of my property. They also awarded $400,000 in punitive damages against Karen Reynolds personally, finding that her conduct was willful and malicious. I heard Karen gasp behind me. $400,000 was a staggering sum, designed to punish and deter similar conduct. But the jury wasn't done. On the question of attorney's fees under Section 1983, Judge Chen would make a separate determination, but the jury's verdict meant I was entitled to recover my legal costs from the defendants. Judge Chen thanked the jury for their service and dismissed them. Then she addressed the parties. I'll enter judgment in accordance with the verdict. The defendants are ordered to immediately remove all fines and violations against Mr. Elliott's property and to release the lien. Mr. Morrison, please submit a motion for attorney's fees within 30 days with appropriate documentation. Davenport stood. Your Honor, we intend to appeal this verdict. We'd like to request a stay of judgment pending appeal. Judge Chen looked unimpressed. Motion denied. The jury has spoken and their verdict is well supported by the evidence. I see no basis for a stay. The judgment will be entered immediately. I felt a wave of relief wash over me. It was over. We'd won. But there was still one more chapter to this story. After the trial, several homeowners from Mountain Vista Estates approached me. They'd been emboldened by the verdict and wanted to take action against Karen. Tom Hartley organized a special meeting of the HOA membership to hold a vote on removing Karen from the board and installing new leadership. The meeting was held 2 weeks after the trial. Over 40 homeowners showed up, the largest turnout in the development's history. Tom made a motion to remove Karen Reynolds as president and to remove Derek Reynolds from all HOA committees. The motion passed overwhelmingly, with only 3 votes against. A new board was elected, including Tom as president. One of their first actions was to commission an independent audit of the HOA's finances during Karen's tenure. The audit revealed that Karen had been paying herself an unauthorized administrative fee of $500 per month for the past 2 years, totaling $12,000 in misappropriated funds. The new board filed a complaint with the local district attorney's office. After investigation, the DA brought criminal charges against Karen for embezzlement and misuse of fiduciary funds. She eventually pleaded guilty to a reduced charge and was sentenced to 6 months of house arrest, 3 years of probation, and restitution of the $12,000 she'd stolen. Derek Reynolds and his fiancée ended up buying a different property in a neighboring development. I heard through the grapevine that the engagement was called off a few months later, and Derek moved back to Raleigh. As for me, Judge Chen ultimately awarded me an additional $130,000 in attorney's fees to be paid by the defendants. Combined with the damages award, I recovered far more than I'd spent on legal fees. More importantly, I'd vindicated my rights and exposed Karen's corruption. The Mountain Vista Estates HOA, under new leadership, formally apologized to me and several other homeowners who'd been targeted by Karen. They held a vote to revert to the original 1972 covenants, properly recorded the decision with the county, and implemented new procedures to prevent future abuse of authority. I still own the cabin today. It's still my mountain retreat, still has natural wood siding and native landscaping, and still offers that breathtaking view of the Blue Ridge Mountains. I go there as often as I can, usually every other weekend, sometimes just to sit on the deck and watch the sunset. Last summer, I had a small plaque made and mounted it on a post near my driveway. It reads, "This property is maintained in accordance with the original Mountain Vista Estates covenants, as approved by its rightful owners and upheld by the United States District Court. No unauthorized HOA official shall trespass or harass the owner. Violators will be prosecuted." It's probably a bit petty, but after everything I went through, I think I've earned the right to be a little petty. Tom Hartley and I became good friends. He's retired now and lives at his cabin full-time. We get together for beers on his deck every few weeks and talk about life, politics, and the absurdity of HOA drama. He jokes that I'm a local legend in Mountain Vista Estates, the man who stood up to the tyrant and won. I don't think of myself as any kind of hero. I was just a guy who refused to be bullied out of property that meant something to me. But I've heard from dozens of people over the past year who've reached out to share their own HOA horror stories. Many of them feel powerless against aggressive HOA boards. I always tell them the same thing. Document everything, know your rights, and don't be afraid to stand up for yourself. HOAs aren't above the law, and board members who abuse their authority can be held accountable. The case also had broader implications. Judge Chen's ruling that HOA actions could constitute state action under certain circumstances was cited in several subsequent cases across the country. It contributed to a growing body of law, recognizing that HOAs exercise significant power over property rights and that this power must be exercised fairly and without corruption. Several states have since passed legislation strengthening homeowner protections against HOA overreach, establishing clearer procedures for covenant amendments, and creating oversight mechanisms for HOA finances. I'd like to think our case played a small part in that reform movement. Karen Reynolds moved away from the area about a year after the trial. I heard she relocated to Florida, where presumably she's starting fresh. I hope she learned something from the experience, though I'm not particularly optimistic. People like Karen usually don't change. They just find new situations where they can exercise control over others. Derek, as far as I know, is working in some kind of sales job in Raleigh and keeps a low profile. I doubt he'll be trying to lowball anyone on cabin purchases anytime soon. The last time I was at the cabin, I spent an afternoon going through some of my grandfather's old things that I'd stored in the attic. I found a box of photographs from the 1970s, when he first built the place. There were pictures of him and my grandmother on the deck, raising their first toast to their mountain getaway. There were pictures of my father as a young man, helping to stain the wood siding. There were pictures of me as a kid, holding up a fish I'd caught in the nearby stream. Looking at those photos, I felt a deep sense of gratitude that I'd fought to keep this place. It's not just a cabin. It's a repository of family memories, a connection to my grandfather, a link to my past. If I'd given in to Karen's pressure and sold to Derek for that insulting offer, all of that would have been lost. That's what Karen never understood. To her, my property was just a real estate transaction, an asset to be acquired for her son's benefit. She couldn't comprehend that it represented something far more valuable than its market price. She couldn't understand that some things aren't for sale at any price. I think that's the real lesson from all of this. Property rights aren't just about money. They're about autonomy, security, and the freedom to make choices about your own life. When someone tries to use power or authority to strip away those rights, it's not just a legal violation, it's a fundamental assault on human dignity. I'm glad I fought back. I'm glad I refused to be intimidated. And I'm glad that, in the end, justice prevailed. These days, Mountain Vista Estates is a much better place to live. The new board is transparent and responsive. They've simplified the rules and focused on genuine community needs rather than petty enforcement. They've organized neighborhood events and improved the common areas. Several new families have moved in, attracted by the reformed HOA and the community's improved reputation. I've even become more involved in the HOA myself, serving on a committee to review and update policies. It's ironic, given that I was once the HOA's target, but I figure the best way to prevent future abuse is to be part of the solution. We've implemented requirements for financial transparency, term limits for board members, and an independent review process for covenant enforcement actions. We've also established a homeowner bill of rights that protects residents from arbitrary or selective enforcement. Tom jokes that I've gone from rebel to reformer. Maybe he's right, but I prefer to think of it as protecting other homeowners from going through what I experienced. If my involvement helps prevent even one person from being victimized by a corrupt HOA official, it will have been worth it. My legal battle with Karen Reynolds in the Mountain Vista Estates HOA consumed 2 years of my life. cost me enormous stress and anxiety, and forced me to spend tens of thousands of dollars on legal fees. But it also taught me valuable lessons about standing up for what's right, about the importance of property rights, and about the capacity of ordinary people to fight back against abuse of authority. Would I do it all over again if I had to? Absolutely. Without hesitation. Because some things are worth fighting for. Family legacy is worth fighting for. Justice is worth fighting for. And the right to enjoy your own property without harassment or intimidation is definitely worth fighting for. I still practice software development in Charlotte during the week. I still drive up to the cabin most weekends. I still sit on that deck and watch the sunset behind the mountains, painting the sky in brilliant shades of orange and purple. But now, when I sit there, I feel something I didn't feel during those dark months of conflict with Karen. I feel peace. I feel security. I feel the satisfaction of knowing that I fought for what was mine and won. The cabin is mine. The land is mine. The view is mine. And no corrupt HOA president or her entitled son can ever take that away from me. That's the ending I fought for. And that's the ending I got.